My Lord, at the very outset, it cannot be gainsaid that court orders are not suggestions. Court orders are decrees that are meant to be obeyed, and they are issued, my Lord, with the desire that they will be implemented fully as the court so directed. My Lord, what is clear from the cross-examination and the examination in chief of the various witnesses that have been called or that were summoned before this honorable court is that there are practical situations that have disabled the individuals that were directed by the court to do certain things. So that even in the face of the court order that was issued by my Lord Justice Bahati Wambui on the 12th day of June 2025, it appears that there is a practical inability by persons that were directed to do certain things. And it is for that reason that my senior counsel and the president of the Law Society of Kenya has invited this honorable court to cite various persons for being in contempt of court, and various orders have also been made, or rather there has been submissions made by counsel to make further orders to ensure compliance with the court order. My Lord, I will stick strictly and with humility direct the attention of the court to order number 5 that was issued by my Lord Justice Bahati Wambui, which is one of those traditional judicial review orders of mandamus granted or directed to be granted, directed to the 6th respondent to re-register Gatoto Community Primary School. My Lord, even as I put a finger on that court order, I'm equally minded that my Lord directed the compliance of that court order within the meaning of the Basic Education Act. Of the year 2013. Section 95 of the Basic Education Act 2013 grants and indeed granted the Cabinet Secretary in charge of education the power to develop guidelines to ensure the strict compliance with the Basic Education Act.
Section 9?
Section 95, my Lord.
Yes.
My Lord, it is in the discharge of the power granted to the Minister in charge of education that guidelines, this is the registration guidelines for basic education institutions of the year 2021 were developed. My Lord, the law and the guidelines enjoy a presumption of constitutionality. In any event, they have not been a subject of challenge before the Honorable Court. And paragraph 6 of the guidelines prescribes what is called the registration of educational institutions. And it proceeds to document that institutions shall be assessed and re-registered afresh when they change from public to private or from private to public, among other factors. My Lord, it is for this reason that, in my very humble view, I submit that it was not lost in the mind of the learned judge, my Lord Justice Bahati Wambui, to order a registration in compliance or within the meaning of the Basic Education Act. Therefore, reading the law, reading the orders that were made by the Honorable Judge, we must inevitably agree that indeed, over and above the imposition of duty to register, the respondents, the 6th respondent and the 7th respondent, were duty-bound to follow the Basic Education Act and the guidelines developed that have not been a subject of challenge before this Honorable Court. My Lord, with respect, I proceed to make the submission that, my Lord, perhaps before the court can proceed to either cite the respondents for being in contempt of court order, the court, when it retires to the privacy of its chamber, must first consider whether the explanation that has been offered by the 7th respondent, Mr. Reuben, that explanation has been offered within the confines of the law to demonstrate that indeed there has not been any willful non-compliance with the court order that was issued on the 12th day of June 2025. My Lord, therefore, the orders or the reliefs that have been subsequently sought by my President, Senior Counsel Kanjama, for the court now to make certain further decrees and to direct the 7th respondent, who it is not disputed that he sits on that seat in his capacity as the secretary to a board. And therefore, any of the power that he has is subject to the meetings that are authorized by law. Meetings, my Lord, whose agenda is to satisfy legal requirements. The invitation by my senior is, in other words, to invite the court to displace an authority that has been placed on the shoulders of the 7th respondent and the board in place of an order that will otherwise be said to have traveled further than what the confines of the law so require. So, my Lord, in closing, I will ask with humility that there is need for the court to further and deeply introspect the practical inabilities that the respondents currently are facing that have hindered the full satisfaction of order number 5 that was issued by my Lord Justice Bahati Wambui. My Lord, while the respondents have a duty the satisfaction of that duty is so much dependent on the discharge of certain other duties by the petitioners. It is not difficult, my lord, to compare what is before the Honorable Court with a relay race. He can't run if the mantle is not passed legally to him.
No, I'm not asking for it. Thank you. I will look for it myself. You indicated that these guidelines enjoy the presumption of constitutionality.
Yes, my lord.
Which I understand you to be saying that these guidelines have some bindingness, if I may say so.
Bindingness on the people who are supposed to execute them.
Yes.
Indeed, my lord.
Yes. Senior Counsel Kajama referred to 2015 guidelines.
Yes, my lord.
And you've referred to 2021 guidelines.
Indeed, my lord.
Okay. How do these guidelines function? Does the 2021 guidelines repeal the 2015 guidelines?
My lord, not quite expressly so. Perhaps one would say that the latest guidelines are meant to fill certain gaps, probably that were seen during the implementation of the first guidelines. In any event, the guidelines
so
are actually developed.
There is no implied repeal, there is no repeal of the previous guidelines?
Not quite, but if there was any weight to be placed, then I would imagine, my lord, that the court will place so much weight on the recently
mean
developed.
that the previous guidelines, the 2015 guidelines,
yes,
that those words updates are still, going by what you say, still in force?
my lord, with
We have not read.
with the 2021 guidelines, weight should be placed on them as opposed to.
Well, you did indicate that
Yes.
they don't repeal the previous guidelines, that the new guidelines are supplemental.
Yes, they are meant to fill gaps,
They are meant to fill gaps.
to ensure
So
that we have
means,
quality assurance.
So that means the 2015 guidelines that mention updates are not repealed.
Not sure.
Not repealed, my lord, but when we are called upon to place them on a scale, then ordinarily the 2021 would be the ones that will carry the weight to persuade the
I
court.
agree with you. I
Yes.
agree with you that anything that is new carries more weight than something that is old.
Yes.
All I'm saying is there anywhere where those 2015 guidelines have been repealed?
My lord, I have not seen where there is an express directive of that.
Okay.
Yes.
So maybe then that would mean that the 2015 guidelines, though on update, are still binding.
My lord, I will be shy to make that conclusion.
Okay.
Thank you.
Okay, thank you.